my camera, so I'll just be speaking. You hear me through the audio. Inam is a partner at Templars and has been in active legal practice for 31 years. He's the head of the labor and employment practice of the firm and holds a Master's of Laws degree in Maritime and Commercial Law from the Lagos State University, Lagos, Nigeria. As an employment law expert, Inam regularly advises multi-sector clients ranging from SMEs to multinationals on employment, labor, and trade union-related issues arising from their day-to-day operations and extending to complex corporate commercial transactions, including corporate restructuring and acquisitions, structuring and restructuring employment relationships, labor outsourcing, etc. He's also an expert negotiator and has assisted several clients in negotiating terms and conditions of high-profile employment, both on an individual basis and under the aegis of different trade unions. Inam is overly familiar with recent global trends in the employment space and is one of the leading lawyers practicing actively in the National Industrial Court of Nigeria and contributing to the development of labor jurisprudence in Nigeria. He has presented a litany of seminal papers, written a plethora of articles, and co-authored books in diverse areas of law with emphasis on labor and employment law, shipping and maritime, oil and gas, etc. Oh, I see. I can see that Dr. Akombi has joined us. My apologies, but Dr. Akombi, can you hear me? Okay, so it is my pleasure to introduce Mr. Inam Wilson for the first session today. And Inam will be speaking on outsourcing. And after Inam's session, we'll then have Dr. Akombi speak to us on trade disputes. Dr. Akombi, I was just saying to you that because you joined in a bit late, we just swapped the schedule so that Inam goes first. I hope that is okay.
Yeah, that's okay. Good afternoon.
Okay, thank you very much. So Inam, here you go.
Good afternoon, everyone. I hope everyone can hear me.
We can hear you.
Okay. Good afternoon again, everyone. Good afternoon, my Lord, Honorable Justice B.B. Kanye, and good afternoon, panelists, and good afternoon, members of the audience online. Thank you again for this privilege to share my thoughts on making outsourcing work. I will try to make it short and try to make it as practical as possible. And for those who were in attendance during the first session on the last week Friday that my Lord Honorable Justice Kanye gave his presentation, I hope you had you enjoyed the session and you found it very informative. And I will just try to add a few things to some of the things that came out during the session of Honorable Justice Kanye. And my intention really is to provoke thoughts and raise questions. And because my Lord is here, we will hopefully find answers to those questions as it relates to outsourcing. To make it efficient, I have taken the liberty to slightly tweak the topic to make it specific to labor outsourcing, because outsourcing, as we all know, is a wide concept and it includes labor outsourcing. So I have decided to take the liberty to speak on making labor outsourcing work in Nigeria. And I have also set for me the scope of the presentation, the first of which would be to understand the concept of labor outsourcing. Then I'll try to deal with the legal regime. As I understand it, the regime is both statutory and judicial, with the judicial regime taking the lion's share, and then If we have time, I'll look at global best practices and then my conclusions and recommendations. I tried to interrogate the topic, which is making outsourcing work. And from my interrogation, it appears that there's a cryptic message or suggestion that outsourcing has not quite particularly worked well in Nigeria, especially from the employee perspective. And I took the liberty to set out certain quotes from my Lord Honorable Justice Kanyip. My Lord, with your kind permission, I've quoted extensively from 2 papers that my Lord delivered. And I have derived a lot of inspiration from those papers. So I should acknowledge at this point that some of the thoughts that are here are thoughts expressed by my Lord. The first paper was the Nigerian Labour Act in 21st Century, the need for reform, which my Lord presented on the 8th of December 2015 at a national workshop on reform of the Labour Act. And then the second paper was titled Developing Trends on Labor Outsourcing and Triangular Employment, the Issues, which my Lord delivered as a lead paper on the 7th of May 2019 at the AGM, or Annual General Conference, dinner of the 2019 conference of, I think it's the MBA, which was held on the 8th of May 2019. I quoted my Lord's statement because it sort of captures in clear terms the dynamics of outsourcing, especially in Nigeria. And I will read. The first quote starts with, globalization has thrust on us new forms of work organization, such as outsourcing and contracting out, which has contributed to the emergence of economically dependent work, otherwise called quasi-subordinate work or atypical work. According to Richard Miller, workers in this category fall within the broader category of the labor force that generally exists in a kind of economic and legal limbo. He continued that although employed, these workers often remain in the margin of the typical employer's workforce without job security, benefits, or legal protection. They are variously referred to as contingent, flexible, atypical, secondary, just-in-time, marginal, or disposable employees. And they come in a variety of guises of employment, which include part-time, casual, temporary, leased, agency, subcontract, homework, fixed duration, or project, on-call, or pool workers. Howsoever they come, they are characterized by their intermittent, temporary nature, where they lack job security of the core employees and are generally without access to job ladders, training, fringe benefits, and legal protections possessed by core employment. The latter part of the statement, I think, captures the issues from the employee perspective, which is lack of job security, which is available to core employees, or generally, they don't have access to job ladders, training, fringe benefits, or legal protections possessed by core employees. In the second statement, which also I will quote at length, because again, it captures the issues. I quote again, my Lord. I must make the point. These advantages and disadvantages of outsourcing, as can be seen, are advantages and disadvantages, especially from a business, hence employer standpoint. Despite that outsourcing is itself a veritable source of employment, labor is often quick to kick against it. And here, majority of the cases brought to the National Industrial Court by labor often calls for it to be declared unlawful. And similar calls have also been made to the Minister of Labor, despite that the International Labour Organization does not see it as such. Even as a source of employment, labor questions. This is labor questions. What sort of employment, when often than not, it is an indignity to the employee? Here, labor is concerned with not just the fact of the employment, but the dignity associated with it. After all, a cardinal principle in the world of work is dignity in labor. There is nothing dignifying about an outsourced employee doing about the same job, sometimes at a higher quality as an internal employee, but at a lower pace. So these two statements captures the issues, which is that from the employer perspective, outsourcing is a great innovation. It helps to manage costs. It helps to manage the books of the firm. It helps to make the company, in the eyes of the employer, efficient. And then it takes certain legal risk away from the employer and passes it on to a third party. But from the employer's perspective, the outsourced employee finds himself in a legal quagmire where he feels disadvantaged when you compare him to the regular employee. So my take is this, before I go into the meat and the nitty-gritty of my paper. To use the word of, again, Justice Kanye, labor jurisprudence in Nigeria is in a state of crisis. He didn't put it that way, but I'm paraphrasing. In my words, the labor and employment jurisprudence is changing dramatically, and the old boundaries set by the common law are being challenged and in most cases obtained. So while there are underlying good intentions in outsourcing, the unintended consequences of the decisions of the NIC on labor outsourcing and contract staffing has the tendency or potential and risk of interfering with commercial contracts with adverse effects on economic activities and job creation. In my view, to make outsourcing work, there must be a new statutory regime. And then pending that, decisions of the NIC must reflect commercial realities. So that's my take in essence. Understanding the concept of outsourcing. I think it's pretty much clear from the statement of Honorable Justice Kanye what outsourcing is. So there is the traditional forms of outsourcing that most of us are familiar with, which involves a third party, three parties. But today, with the world of technology and advancement in information technology, sometimes it does not even have to involve third parties. Sometimes, like today, it involves apps and artificial intelligence. And so you might find in certain situations that outsourcing involves a process where an organization secures a set of its services performed by another organization. So in this case, you have, for instance, the contracting party, company A, and the contractor company, company B. That company A outsources certain of its services to company B. And sometimes those services include the provision of labor services. So the labor provider, the labor or employees now work with company A, even though on paper or under the arrangement, they are employees of company B. So this creates a tripartite arrangement And this has yielded to modern terms, for those of us in the employment law circle, that we understand as co-employer principle and triangular employment. So triangular employment is a relationship where a person called labor contractor recruits personnel and deploys them to a client company or end users on a needs basis. By this arrangement, there's usually a contract of employment between the deployed employee on the one hand and the labor contractor on the other. However, there is no contractual relationship between the employee and the client or end user company, even though that employee works directly with the client or end user company. The International Labour Organization calls this a disguised or objectively ambiguous employment relationship, which is meant to either mask the identity of the employer, where the person designated as employer is an intermediary with the intention of releasing the real employer from any involvement in the employment relationship, and above all, from any responsibility to the workers, or marks the form in which the relationship is established. I had also mentioned earlier about the use of apps or app companies. And those familiar with the Uber case will relate to this very well. So you have an app company or apps that engages or involve drivers, because those are the Uber cases. Uber and Bolt, they have those cases. And so the question is, are the employees of the app company or the company that engage the app company, or they are independent contractors? The decision of the UK Supreme Court, House of Lords recently, has settled the issue as far as the UK position is concerned. In the case of Uber BV against Yassin Aslam, the court held that Uber drivers are workers, not independent contractors. The court cited the practical reality of the relationship, as well as the degree of control Uber exerts over the drivers. Again, note that what the court considered was the UK legislation. So the court interpreted a UK legislation on the definition of worker. And based on that definition and applying that to the practical reality of the relationship, the court held that Uber drivers were the workers of Uber and not independent contractors. And so it is interesting that in that particular case, Uber sought to rely on the contracts. First, the contract between the employee, the drivers, and the app company provider, as well as the non-existence of a contract between the drivers and Uber itself. But the court said, this case is not about the interpretation of the contract. Rather, it is the interpretation of the statutory provisions and the definition of a worker. And by that definition, the court took the view that the definition of worker extended beyond the mere worker, but also included independent contractors. And so for that reason, the Uber drivers are workers. The industrial court had an opportunity of pronouncing on the same issue much earlier, but passed the opportunity. This was in the case of Oladapo Olatunji against Uber Technology System Nigeria Limited. The case was, of course, dismissed on technical grounds, and so the substance of the issue were not discussed. I now move on to take quick brief look at the statutory regime regulating outsourcing in Nigeria. My research shows that there are two, or should I say three? I say two, but three, if I'm to include the Labor Act. Perhaps, my Lord, from the decisions that came out of the NIC, will be inclined to include the Labor Act in determining the statutory regulation of outsourcing. There is the guidelines on contract staffing and outsourcing issued by the Federal Ministry of Labor, but this guideline is sector specific, and it is specific to the oil and gas industry. This guideline was issued in 2011, and this was, in my view, the first statutory recognition of outsourcing in Nigeria. And it sought to provide the legal framework for regulation of outsourcing. The myth of that, the pith, the kernel of that guideline is that oil service companies are permitted to outsource non-core services. So although non-core services are not defined, but it gave the oil and gas companies the liberty to outsource services which they consider to be non-core to oil exploration or oil drilling or oil marketing, as the case may be. And so it became legal under this regulation for you to have two categories of employees in the oil sector: the regular staff and the contract staff or outsourced staff. However, the guideline sets certain standards, which is if there is a vacancy, for instance, in a position occupied by a regular staff, the contract staff should be given an opportunity to fill that vacancy, provided that the regular staff is qualified to fill that position. So it basically gives the regular staff a right of first refusal or preemptive right, as the case may be. Then, of course, it recognizes the right of contract staff to be unionized and prevents employers from overtly or covertly hindering the unionization of contract staff. So basically, the whole essence was to balance the requirement for job security as well as flexibility in the operation of the business. So that is about the guidelines. I am aware that there is a bill pending before the National Assembly at the moment. I'm not sure the bill has gone very far for whatever reason, but this bill intends to regulate outsourcing. It's called the Labor Act Amendment Bill 2019. And Section 9 of that bill, interestingly, provides as follows. Notwithstanding Section 25 of this Act, an employer who has obtained the minister's license, employment outsourcing by such employers within its core aims and objectives of operation is hereby prohibited. It is an offense for an employer to pay another person, whether corporate or natural, for service rendered to it by its workers. So basically, what this tries to do is to say that outsourcing is prohibited. Like I said, I don't know the fate of this act, this bill. It hasn't seen the light of day yet. And I am not sure that it will see the light of day very soon, but who am I to be pessimistic? My attention was drawn also while I was preparing for this paper to a a draft document prepared by the Nigerian Information Technology Development Agency. This document seeks to regulate outsourcing, but it is in draft form. And so my research did not confirm if it is operative or not. But basically, my reading, my quick review of this document is called the National Outsourcing Strategy 2020, which was made pursuant to the National Outsourcing Policy of 2007. The essence of this, like the guidelines issued by the Federal Ministry of Labor, is to regulate outsourcing in the information technology space, and then make provisions for outsourcing to work in that space. So that is the legal regime as far as I see. Of course, like I said previously, there is also Section 91 of the Labor Act, which the court has interpreted to mean that it extends to not just your core employers, but also persons that provide other forms of services like agencies. And so by extension, my understanding is that the court takes the view that Section 91 will apply to outsourcing in Nigeria. As a matter of fact, there's a case I did in National Industrial Court where the court applied Section 91 to impute a triangular employment relationship between the company, the contracting company, and the employee. I now move on to judicial regulation of outsourcing. Clearly, in view of the lacuna in statutory regulation of outsourcing, it becomes necessary for the National Industrial Courts to take the forefront to regulate outsourcing. And a lot of decisions have come out of this court, especially on the twin issue of co-employer relationship and triangular employment relationship. And in some of the decisions, I see some thought that goes into it. First, attempt to establish best international practices, an attempt to balance the scale between the employer and the employee. And so there are decisions where there's one or two cases, especially delivered by my lord, where my lord took reliance on UK decisions and also decisions from the courts in India. Anyway, I think the bottom line from the industrial court's perspective is that, and this is in relation to the issue, like I said earlier, the application or interpretation or the decisions that have come from this court has been that sometimes the court has departed from what I thought were settled common law principles in its attempt to determine whether an employment relationship exists between the employer, the end user, the contracting company, and the employee. And my understanding behind the thinking is that the National Industrial Court is not just a court for the interpretation of contracts, but it's also a court that ensures that contractual provisions are not servile in nature. So that's my reading. Now, my understanding of the cases that have come out, I have identified some common law principles that have been, should I say, limited in application, circumscribed, if I can use the word, or sometimes outrightly made inapplicable. One of those principles is the separate legal personality principle. Now, everybody knows it, that a company is different from its shareholders. And a company has different legal personality distinct from its members, its affiliates, its parent company, or even its subsidiaries, except in rare cases where the veil of incorporation is lifted. And these are cases which involves fraudulent practices, or where the company is used as a facade. And so we find that the courts, in certain cases, have made away or disregarded separate legal personality principle. Now, in Oyewumi Oyetayo against Zenith Bank, the NIC took the view that Zenith Bank and its subsidiaries, Zenith Securities Limited, were co-employers of the claimant based on the co-employer principle. The court rejected the argument of Zenith Bank that the transfer of the claimant to its subsidiaries, Zenith Subsidiaries Limited, and the confirmation of the claimant's appointment as staff of Zenith Securities Limited presupposes that the claimant is no longer the employee of Zenith Bank, but that of Zenith Security Limited, the new employer. The court rejected this argument. Also, in the case of Madoka against Microsoft, one of the locus classicus in sexual harassment in Nigeria at the workplace, the NICN found that the first respondent, which is Microsoft Nigeria Limited, who actually employed the claimant, was the agent of his parent company, which is Microsoft Corporation, for the purpose of employment of the claimant, and therefore both were co-employers of the claimant. My reading and my understanding of the basis of the decision was that even though the claimant was an employee of Microsoft Nigeria, her employment was subject to and governed by the worldwide policies of Microsoft Corporation, which affects all employees, subsidiaries, and affiliates of Microsoft worldwide. Another common law principle that has received a hit from the National Industrial Court is the sanctity and privity of contract principle. Again, this principle says the court's duty is to interpret and apply the contracts as agreed by the parties. By the doctrine of privity, a contract cannot confer rights or impose obligations on any person who is not a party to the contract. In effect, parties are not bound to respect, observe, and perform a contract they did not enter into. As such, an action brought by a party to a contract against a person who is not a party or privy to that contract is incompetent for want of privity. The NICN, in a number of cases, have taken a different position in view of the doctrine of privity. And my Lord alluded to this in my Lord's presentation last week, Friday. So the NICN takes the position that when there is a co-employment or triangular employment relationship, the court will overlook the privity contract, the privity principle, privity of contract principle. For instance, in Anthony Agum against United Cement Company, the first defendant entered into a service contract with an outsourcing company called MS Outsourcing Services as an independent contractor for the provision and management of drivers, cooks, and stewards. Pursuant to the service contract, the second defendant employed the claimant and assigned him to the first defendant. So clearly, there's no contract of employment between the claimant and the first defendant. And the payment of the claimant's salary was the sole responsibility of second defendant. Nevertheless, the NICN found that the parties had a co-employment or triangular employment relationship because the claimant was employed by the first defendant and posted to work with the second defendant. In another case, Morrison Owupele Inimba against Integrated Corporate Services Limited. The first defendant, Integrated Corporate Services Limited, ICSL, employed the claimant and seconded him to the second defendant, EcoBank Nigeria, to work as transaction officer stroke posting teller. Notwithstanding that there was no contract of employment between the claimant and the bank, the court, relying on ICSL's letter of offer of employment, which specifically stated that the claimant will be employed as a transaction officer and seconded to Oceanic International Bank PLC. The court held that ICSL was an agent or tool of the bank for the purpose of employing the claimant for itself. And this is the spirit and the text of Section 91 of the Labor Act, if I may add. On this basis, the NICN held that the bank and ICSL were co-employers. Now, in Olalekan Kehinde against Airtel Nigeria Limited, the NICN gave little weight to letters of offer of employment and fixed-term employment contracts issued to the claimants by third parties. The rationale, from my understanding, for this decision was that Airtel initially employed the claimants, confirmed them, and even reviewed their salaries before it orchestrated their movement from one employer to another. All of its benefits, all for its benefit, but these movements were not meant to bring to an end the employer-employee relationship between Airtel and the claimant. Another common law principle circumscribed by the decision of the NIC is that the contract of employment is the bedrock of employer-employee relationship. This is closely tied to the privity of contract rule. The NIC takes the position sometimes that the contract of employment, the bedrock of an employee-employer relationship, is the contract of employment. However, the NIC is minded to even impute an employer-employee relationship even in the absence of a contract of employment. In Diamond Bank PLC against National Union of Banks, Insurance and Financial Institutions employees, the bank's policy and practice was not to employ certain cadre of workers, but to outsource the provision of such services under a labor service agreement to contractors who send their employees to the bank to perform the services. The contractor is responsible for the employment, condition of service, remuneration, discipline, welfare, promotion, and disengagement of such workers sent to the bank. The bank entered into a labor service agreement with C&M Exchange Limited, the contractor, and the employees of the contractor who were members of the defendant union worked in the bank. In determining whether the workers must have a contract of employment with the bank before they can picket the bank, the court held that the labor service agreement effectively created a triangular employment relationship between the bank, C&M Exchange Limited, and the workers, or a disguised employment relationship. The court held further that in cases of triangular disguised employment relationship, the ILO enjoins on court to observe the principle of primacy of facts, that is to emphasize the substance over the form of the relationship. The court found that the substance of the relationship between the parties is one of a triangular employment relationship for which the bank was a co-employer of the workers. Finally, the decisions of the NIC affecting the rule that court cannot read terms into a contract of employment or create a contract for the parties. The co-employer principle appears to derogate from this long-held common law rule. that where the parties have embodied the terms of their agreement in a written document, extrinsic or external evidence is not admissible to add to, vary, or subtract from, or contradict the terms of the written contract, the document. The rule serves to bar the court from reading terms into a contract or creating contract for the parties. In the case of Diamond Bank PLC against National Union of Banks, Financial Institutions, Employees, the NICN went at great length to explain how the new realities in the jurisprudence of the court makes it imperative for the court to depart from this long-established rule. The following were given as a rationale for this disposition by the NICN. 1, in an employer-employee or master-servant relationship, in addition to the express terms of the contract, the law imposes certain implied terms into the contract. These implied terms may either be founded on statute, by custom, by practice, or public policy, so as to ensure that the master does not subjugate the servant to a condition of servitude or slavery or like terms. The industrial courts, in the course of adjudication of disputes, so this is the second point, the industrial court in the course of adjudication of disputes between employers and their workmen must determine the rights and wrong of the claim made. And in so doing, they are undoubtedly free to apply the principles of justice, equity, and good conscience, keeping in view the further principle that their jurisdiction is invoked not for the enforcement of mere contractual rights, but for preventing labor practices regarded as unfair, for restoring industrial peace on the basis of collective bargaining. The third point made by the court is that agreements can be disregarded by the courts, especially if they are a false portrayal of the relationship between the parties, and employment judges and tribunals must be realistic and worldly wise. That is in quotes. They must be realistic and worldly wise, and should take a sensible and robust view of these matters in order to prevent form undermining substance. The final point made is the goal of labor law is to ensure that no employer can be allowed to impose and no worker can be allowed to accept conditions of work which fall below what is understood to be a decent work. So this is the position as I understand it from the NICN. Let me sit back a bit and try to wrap this all up. So clearly, the NICN, as I understand it, is trying to say that, number one, much as the NICN will respect contractual relationships, it has to take into consideration the substance of those relationships beyond the form. And so in clear cases, the NICN will depart from an agreement, for instance, or what is clearly the lack of a relationship, and impute the existence of an agreement or impute the existence of a contractual relationship. The question now I ask, does this spell doom and gloom for outsourcing? It appears to me that it doesn't. And my reading again through the cases suggests to me that in certain cases, all that determining the employment relationship does is to determine who the employer is or who the employers are. At the end of the day, when you have determined and established who the employers are, or the employees, the question will now be, as concerning the claims of the parties, is there any merit to those claims? From my reading of the decisions of the NIC, it appears that even in certain situations where the NIC has held that a co-employer relationship exists, the NICN has nevertheless gone further in some cases to dismiss the claim of the plaintiff and to say that, yes, we agree that the X, A or B is your employer, but the claim that you're asking for, the benefits that you seek to claim, have not been established. And so this puts a balance, in my view, in the decisions of the NICN. And some of those cases are clear. For instance, the case decided by my lord, Pengasin against Mobile Producing Nigeria Unlimited. The question was on the facts and the evidence presented to the IAP. This was a matter that came through the IAP, Industrial Arbitration Panel. Was MPNU, which is Mobile Producing Nigeria Unlimited, the employer of the sacked members of Pengasin? Guided by the principle of primacy of facts enjoined by the ILO in determining the existence of an employment relationship, the court focused on the facts of what was actually agreed and performed by the parties and not the name they gave the contract. Accordingly, the court held that there was no employment relationship between MPNU and the workers based on a number of facts, one of which was there was no contract of employment between the staff and MPNU. Secondly, the forum of contractors were the employers of the staff and responsible for the performance appraisal of the staff. Thirdly, the collective agreement was between the union and the forum of contractors, and MPNU was not a signatory to the collective agreement. Fourthly, the union was aware of the full nature of the triangular employment relationship. Hence, the label of its branch as union, a branch of the union as Pengasin, contract staff branch in MPNU and EEPNL locations. It is under this name that the collective agreement was entered into with the MPNU, with MPN and EEPN, Labor Employers Forum. This collective agreement specifically recognizes and describes the MPN and MPLU as employers of the contract staff. In other words, my Lord Honorable Justice Kanye focused on the primacy of the facts, even if there was, notwithstanding the existence of a triangular employment, my Lord still found that the employers were not, the employer was not MPNU, but the Forum of Contractors. In another case, James Francis Etim against the Ikeja Electricity Distribution Company, PLC. There was a privatization of the component companies which made up Power Holding Company of Nigeria, Ecozone. That is, the companies that made up this company were Ikeja Electricity Distribution PLC and Eco Electricity Distribution PLC. The claimant was transferred by PHCN to the defendant. Prior to the said privatization and even after the transfer, the claimant's salary was paid by PHCN. Despite the transfer, PHCN, Ecozone, continued to be the claimant's employer even after the conclusion of the privatization. While the claimant argued that the transfer was, or at least was the harbinger of a change of employers, the defendant argued that it did not translate to a change of employers. The court acknowledged that the transfer or secondment of an employee by an employer to another employer does not necessarily imply that the transferring employer is no longer an employer of the employee. The court held that the payment of salaries is one of the incidents of contract of service. Whoever pays salary is indicative of being the employer. So despite the transfer, PHCN Ecozone continued to be the claimant's employer. That the defendant granted the claimant annual leave and the claimant worked in the defendant's workplace is not sufficient proof that thereby the claimant became an employee of the defendant. The court therefore declined to apply the co-employer principle, notwithstanding. In another case, Engineer Ignatius Ugoke against Aero Maritime Limited, the NICN held that the transfer or secondment of an employee by an employer to another employer does not necessarily imply that the transferring employee is no longer an employee of the company. The court found that the first defendant was effectively the driving force in the so-called employer-employee relationship between the second defendant and the claimants, and this arrangement was orchestrated by the first defendant for his sole benefit and was not meant to bring to an end the employer-employee relationship between the first defendant and the claimants. So I will now deal with the issue of burden of proving the claims. As we all know, at the end of the day, the primary rule of evidence is he who asserts must prove. So for instance, if you assert that you are the employee of company A, which is the end user, and you're entitled to certain benefits, you must meet the standards of proof required for you to be granted those benefits. The NICN, thankfully, accepts the principle that employee benefits and compensations are in the nature of special damages, and therefore they must be specifically proved, specifically pleaded, and specially proved. And so this standard is applied even in situations where there is a co-employers relationship or tripartite relationship, tripartite employer relationship. For instance, in Morrison Uwupele Iningba against Integrated Corporate Services Limited, the NICN held that the first defendant who employed the claimant and the second defendant to whom the claimant was seconded were co-employers of the claimant. However, the court declined the claim of arrears of salaries and allowances for the following reasons. The court stated, and I quote, "It is not the duty of the court to speculate or to embark on a voyage of discovery." The court quoted and cited UKJ against UKJ, where the Supreme Court held that it is not enough for a party to make an allegation before the court. It must lead credible evidence to prove same. And also the case of Federal Mortgage Bank against ECHO, the court held that when evidence is not led to prove the averment in pleading, the court shall consider the averment as vague and discountenance same. Therefore, based on these authorities, the court held that the claimant failed to prove that he is entitled to arrears of salaries and allowances from the defendant and dismissed the relief. Also, in Oyewumi Oyetayo against Zenith Bank, the court held that Zenith Bank and its subsidiary Zenith Securities were co-employers of the claimant, but dismissed the claimant's claim for salaries, allowances, and other emoluments. The reasoning of the court, I can just give some of them. The court said, while agreeing with the submission of defendant that salaries, allowances, and other emoluments are special damages, which must be specifically pleaded and proved if they are to be claimed. So the claims of the claimant can broadly be said to come under the following heads: unutilized leave days, award, driving license award allowance, no accident allowance, benefits on living services, damages, and cost of filing. And the court went on and on and on. Ultimately, the court held that these claims or entitlements were not claimed, were not proved, and held that the heads of claim were to be dismissed. Similarly, in Olalekon Kehinde against Airtel Nigeria Limited, Airtel Nigeria and Tech Mahindra Nigeria Limited, an outsourcing company, were held to be the co-employers of the claimant. Having held them to be co-employers, the key issue before the court were whether the claimants were actually promoted and then denied their due emoluments arising from such a promotion, from which the claimants are making the claims for bonuses, airtime allowances, and pension fund payments. And who, as between Airtel and Mahindra, is the actual employer of the claimant, so that if the question as to whether the claimants were promoted is answered in the affirmative, the responsibility of paying the difference in salary. The court analyzed the case and ultimately held that, therefore, the claimants have not proved that they were promoted as to be entitled to all the monetary claims that they make in this suit. This being the case, the relief were dismissed. So that's my analysis of the landscape from the judicial perspective. I must not fail to add in conclusion, that all these decisions that I've analyzed are decisions of the National Industrial Court. And in between or since those decisions, we've had one or two decisions trickling from the Court of Appeal. One of them, which is most popular, is the Oak Pension case, in which the Court of Appeal tried to peg back some of these decisions made by the National Industrial Court. One of those points which Oak Pensions highlights is that the court should respect the contract of the parties. But nevertheless, the Court of Appeal recognized that the court, the NICN, is allowed to apply international best practices where it is specially or specifically pleaded and proved by the court. So in conclusion, my take is that there is still a lot of work that needs to be done in this space. And I'm glad that my Lord is here, Honorable Justice Kanye, to make the law in this area of outsourcing first, certain, and as much as possible, predictable. Because as things stand, especially for some of us who've had to advise clients on what the position of the law is, we seem to prevaricate. Sometimes we advise in a certain way, and at other times we advise the opposite. And the reason is because it is not clear. And so I try to hedge on the side of caution to say it depends on the facts and circumstances of the case. And that in certain circumstances, an employer-employee relationship will be implied, and in other cases, it will not. So my take, in concluding, is that this concept of outsourcing is fraught with several challenges, which includes, but it's not limited to, the abuse of the process by the employer. The lack of legislation providing penalties for misconduct, or the lack of legislation also creates a huge lacuna, which the courts have tried to fill. But the decisions of the National Industrial Court itself has been helpful in certain ways, and in other ways have created confusion. And so there is need for uniformity. The best practice would have been to have a specific legislation on outsourcing. I personally do not think that the proposed labor bill is the solution that we need, because it only scratches the surface. My view is that we need a more comprehensive legal regime. In the interim, we'll have to have recourse to the National Industrial Courts to provide clarity and guidance on this subject. Thank you so much for your time. I appreciate your audience. Thank you.
Good afternoon all. Thank you, Mr. Wilson. Just before we get into the question and answer session, I would like to ask our Lordship, Justice Kanye, if he has any comments or contribution before we get into the Q&A section. My Lord.
Thank you. I'll prefer to wait for the question and answers. The only thing I can say is the learned presenter quoted me so much that I don't know what to say any longer. Let me just agree with him and stress one or two things. The essence of outsourcing, you must understand, come in different grades. Within an establishment, there can be several levels of outsourcing, particularly when you're dealing with complex contracts. Within an organization, it's possible to outsource one kind of service to a company. That company can outsource part of what it is doing to another company. So these different levels of outsourcing and sub-outsourcing, if you want to use that term, it's possible to have it and it is prevalent. Secondly, while the presentation was done, I had time to go through the chat and the questions. And of course, some of the things said at the presentation were reiterated in terms of either comments in the chat or questions. But I must also say that the critical factor, because we don't have legislation governing outsourcing, the National Industrial Court is compelled to attend to cases on a case-by-case basis. The general thinking that the judiciary does not make law runs true. But because we have authority to apply international best practice, the expectation is that counsel who file cases and hinge them on outsourcing, for instance, will do the homework by bringing in practices that, if you look at some jurisdictions, the approach to outsourcing differ. There are countries that have made statutory provisions and restricted outsourcing to only certain kinds, like the presenter said, non-essential duties. Because sometimes the essence of outsourcing also has to do with the level of political and economic will in terms of the development aspirations that the country has. If you go to the oil sector, for instance, you ask yourself, do you want to outsource those things that can commonly be done by Nigeria, for instance, to people who are outside Nigeria? These are problems you will have to answer. And because of that, jurisdictions have taken it upon themselves to put down by law the parameters that must be done for outsourcing to be recognized. The presenter made the point, which is valid. ILO does not see outsourcing as an invalid or illegal or unlawful activity. In fact, ILO advises that individual countries, in terms of their judicial processes, should determine, because of the tendency to abuse it. That's why it's called disguised employment relationships. And why is it disguised? Because if you can make an outsourced employee look like he is an independent contractor, then everything about employment protection rules will not apply. So a lot of people, and don't forget, one of the basic philosophies underpinning the world of work today is the clamor by employers for flexibility. In fact, when you have that flexibility, employers are so happy about it. They are not too, because flexibility comes with it, reduce obligations. But don't blame the employer alone. The way the workplace is changing, even employees sometimes ask for it, particularly in developed economies. What we place as value systems differ. An employee could come around and tell you, look, within the day, I want to work for only 2 hours. And the balance of the hours, I want it for myself to do what I want. I want to go climbing. I want to go bird sighting. I want to visit countries at my will. If you give me a paid job that requires me to come to office 8 to 4, I tell you that no, I don't want that. It's too restrictive. So even some employees are happy with flexibility. So don't look at it as if it's a one-sided thing. But the major problem that comes with some of these things, particularly when you look at the interventions by technology. Somebody asked that question, where you have things like Uber and so on. Part of the problem is this. The workplace now is being made to look like, let's make you your own boss. And you feel happy that as your own boss, you are like, how do you put it? You are like, you dictate what you want and you do what you like, when you want it, how you want it. But unfortunately, one other word used to describe this category of people, for instance, is what is called contingent work. But if you look at the word contingent, it underlies something more sinister. And what is that? You are a contingent worker because your work depends or is contingent on work being available in the first place. And because you are a contingent worker, there are some things that come with it. One, you cannot unionize because it is one way to reduce the threat of unionization in the workplace. If we have contingent workers who work from home, it's very difficult for a particular union to say it's going to unionize you from home. So some of these things come as fallbacks. You may call them unintended consequences and so on. And that is why it is necessary. Howsoever we look at it, you can't take away the fact that at one point in time, Parliament or the legislature must come in. They must lay down the parameters, and these are parameters that have to be agreed by all the stakeholders. When I say stakeholders, I'm talking of government, I'm talking of employees, I'm talking of employers. Because they must sit down and agree the parameters in which outsourcing is going to be allowed. But for now, we don't have a choice. NIC will continue to treat with it on a case-by-case basis, based on the injunction of ILO that look at the primacy of facts and decide the matter. So if the facts are such that it moves to a particular, the pendulum moves one way, the tendency is for the court to also move with it in that way. But there's no way an NIC judge today will wake up and give you a hard and fast rule that first, the only thing I can say is that nobody is going to say contingent work or outsourced work is illegal. No, it all depends on how it is put and the parameters, the terms and conditions upon which it is used. If they are too restrictive, of course, based on international practice and how we look at it, there may be a pronouncement in terms of certain parts of the actions. But sometimes, again, like the presenter presented, sometimes we look at it in the holistic form. It may be an escapist attitude, really. Once in a while, you say, look, the way you people have structured this thing, one person is trying to run away from responsibility, one person is trying to push it to another where responsibility is going to be difficult to enforce. So instead of taking all of that, we brand both or all of you as co-employers. Sometimes it's an escapist, but you simply look at the totality of the facts, more importantly, the justice of the case according to your conscience, and then you say, look, there's something untoward going somewhere, and we need to checkmate it. I will still wait for the questions, but it's difficult for any NIC judge to give you a hard and fast rule as to whether outsourcing is legal or not. But the general thinking is that outsourcing is legal to the extent that it does not disturb certain, particularly those things that can be said to be constitutional workplace rights.
Thank you, my lord. So we're just going to go quickly into the questions so that we can go on to the next. So the all the questions on the papers that the paper that has been presented, we're going to send that out. So I'm not going to respond to that. So the first one is outsourcing not directly making pensionable staff contract staff in another form? Mr. Wilson.
The simple answer to that is, depending on the circumstances, the answer may be yes. That's the effect.
Okay, please, what are the likely things to show to establish co-employership?
So you'll find that traditionally where you have maybe a parent company or an affiliate or a subsidiary. So there's a relationship between the two parties or three parties, as the case may be, connection. But more importantly, where the court assumes that one party is an agent for the other party. So if I have a Zenith Bank, for instance, and I have Zenith Securities, they are related. And then Zenith Securities employs you and then seconds you to Zenith Bank. So the court assumes that Zenith Securities is an agent of Zenith Bank for the purpose of your employment. And so a co-employment relationship is created.
Okay, in a co-employment or triangular employment, is a guarantor bound to indemnify any of the employer when there is a loss occasioned by the employee, by an employee?
Please take that again.
In a co-employment or triangular employment, is a guarantor bound to indemnify any of the employer when there is a loss, when there is loss occasioned by an employee? It's possible that, it was supposed to be the other way around.
I don't know who the guarantor is referred to here. My assumption is in certain employments, the employee is required to produce guarantors. And so the guarantors act as guarantors for the employee in the event that the employee commits anything or owes any debt and runs away, they go to the guarantor. That creates that's another legal issue entirely. So you have to look at first laws relating to guarantees. What did the guarantee specify? What's the terms of the guarantee? And all of that to know that. But on the face of it, generally, the essence of having a guarantee is that in the event of the principal defaulting, you have recourse to the guarantor.
Okay, so the next question is, kindly analyze the concept of outsourcing where artificial intelligence is involved.
I think the best case would be Uber or Bolt, as the case may be. So you take, for instance, the drivers. In Nigeria, the way it is operated, the way I understand it to operate is that if you want to sign up to Uber or Bolt, you can do that right from your phone. And then you take your car to a company that would test drive to be sure that the company meets standards set by Uber or Bolt. And then you're signed up. You don't go to an Uber office or a Bolt office. You don't interact with an Uber staff or a Bolt staff. But your terms and conditions of employment as a driver is on your phone, and it will be presented to you through the app. So that's a clear case of artificial intelligence coming into play in this relationship.
Okay, so I'll just take the last question so we can go to the second speaker. And then if there's anything, we will be able to get my Lord's comment before we go into questions from the next speaker. So that last question would be, what is the difference between outsourcing and the agency employer who employs and provide labor to their clients?
The agency employer will very likely feature under an outsourcing arrangement. So, because if you have an outsourcing company, so sometimes that agency can be an outsourcing company, a company whose work is to act as intermediaries for companies. The agency could also be a subsidiary or an affiliate, as the case may be. So it's safe to say that that agency relationship very likely will be a feature of outsourcing, an outsourcing arrangement.
Okay, thank you, Mr. Wilson. I'm just going to quickly introduce the next speaker, who is Dr. Akombi. And yes, so Dr. Akombi is a senior lecturer in the Department of Business Law, Faculty of Law, University of Ilorin, with her areas of expertise being labor law, company law, corporate governance, and arbitration. She's an alumnus of the University of Ilorin, Obafemi Awolowo University, and bagged a PhD from IIUM, Malaysia. She's widely published with her works, receiving critical appraisals and generating interest amongst colleagues and commentators. She has also made several presentations on several areas of law within and outside Nigeria. She's a member of several professional associations, including the Chartered Institute of Arbitration, Arbitrators UK Nigerian branch. Prior to joining the academia, she was a senior state counsel, Ministry of Justice, Kwara State. Dr. Akombi loves to travel, read, and carry out research. So we're just going to go on to you now, Ma, and I trust you have time for question and answer so that we can also have comments from His Lordship before we end the session. Over to you, Ma.
Thank you very much. Good afternoon, everyone. And my Lord Justice Kanye, good afternoon, sir. Inam, good afternoon. Thanks for a beautiful presentation. I'll be talking about trade disputes, how to navigate trade disputes and disciplinaries. And I'll start by saying disputes is a natural, inevitable consequence of our humanity. The very fact that we are humans means that our relationships with each other apologies, please. The network is a bit bad here. Now, I said disputes are inevitable consequence of our humanity. The fact that we're humans means that interactions with each other will often generate differences, disagreements between us. So, what is a trade dispute? I'll start by explaining what a trade dispute is. A dispute literally can be explained to mean a difference, a disagreement, a controversy. So a trade dispute will naturally mean that a difference that occurs as a result of employment relationship. Okay. Sure. Thank you. So like I said earlier, that a trade dispute will therefore mean a difference that results as a result of employment relationship. Now, why trade disputes? One, the inequality of the bargaining power between an employer and an employee. At the onset of the employment relationship, the employer and the employee are usually not on the same footing. Therefore, there is the tendency for a natural suspicion because of that inequality. So naturally, that very fact is the reason why there may be differences, there may be controversies, there may be disagreements. Also, the very fact that the objectives and goals of both parties in an employment relationship, the employer and the employee, are usually different. The employee enters into an employment relationship with the sole aim of bettering or securing some financial security for himself. The employer, at the same time, enters the relationship with the aim of generating profits in the course of rendering services or production of goods. So again, the differences in the goals and objectives of both parties means that dispute is often inevitable. Now, I have broken down disputes into two types, mainly individual disputes and collective disputes. As the name suggests, individual disputes will involve a single employee and his employer, his or her employer, while collective disputes often involves groups or association organizations of employee and employer. So one key thing to notice with regards to the meaning and scope of trade disputes is that the parties involved in a trade dispute must necessarily involve employees and employers. And there must be a relationship, an employment relationship between both parties. And this dispute must occur as a result of the trade or employment between them. So the trade disputes usually involve employer and employee as a result of employment relationship, and the focus of the dispute will involve the terms and conditions of employment or the physical condition of work. So those are the key issues to note with regards to. Now, I said earlier, the focus of this presentation will be on analyzing the mechanisms for the settlement of trade disputes. Now, the basic legal framework for settling trade disputes in Nigeria have identified for legislation, of course, the Constitution as a ground norm, the National Industrial Court Act, the Trade Disputes Act, and the Trade Unions Amendment Act. Now, I would like to go through the provisions of the mechanism, okay? Here I have made a pyramid of settlements where we have 5 levels or 5 stages of trade dispute settlement based on the statutory and judicial legal framework. At the base of the pyramid is the collective bargaining, of course, followed by mediation, conciliation, the intervention of the Industrial Arbitration Panel, and finally the National Industrial Court. Now, as it can be seen from the pyramid of settlement here, the focus of the mechanism for settlement of trade disputes in Nigeria is geared towards alternative dispute resolution. Because at the base of the pyramid is the collective bargaining procedure. And this implies that the parties between themselves must try to resolve the conflict, the dispute, without interference from a third party. This finds legitimacy in provisions of Section 2 of the Trade Dispute Act, which provides that where the parties have agreed on a means of settling disputes, that method agreed on must be resorted to anytime a dispute arises. You know, like I said earlier, that disputes are an inevitable reality of human interactions. So at the beginning of the employment relationship, normally there will be a provision for settling disputes because the parties are aware that disputes are likely to occur in the course of the relationship. So Section 2 of the Trade Dispute Act suggests that when the parties have agreed on a means to settle dispute, that is, the agreement is usually at the beginning of the relationship, that the parties should resort to that method in settling their disputes. Now, with regards to, I noted earlier that there are 2 types of disputes. I have made 2 categorizations: individual disputes and collective disputes. With respect to individual disputes, usually the means of settling disputes will be contained in the terms and agreements of employment. While for collective disputes, it is usually included in collective agreements made by both parties. Now, it is when the parties have attempted to resolve the dispute by themselves based on their agreed mode of settling that if this method fails, then the law, the Trade Disputes Act, provides that the next stage in the pyramid should be followed, which is resulting to mediation. Again, it might be, there might be a situation, pardon me, where the parties have not agreed on a mode of settling disputes. Perhaps the collective agreement between the organization or union of employee and the employer did not include a dispute settlement mechanism. Or even if the parties have attempted to settle through that means and they are unable to reach a compromise, then the Trade Dispute Act provides that the parties should appoint a mediator to settle the dispute. This is provided again for in section 2 sub 2, or section 4 sub 2 of the Trade Disputes Act. Now, it is hoped that after the second stage, after the mediation at the second stage, that the dispute will be brought to an end. However, in some instances, the mediation still fails to resolve the dispute. It is at this stage, when the mediation fails, that the parties are statutorily allowed to declare a dispute. Declaring a dispute by notifying the Minister of Labor that a dispute exists. The parties have tried to settle it within themselves, but have failed. And they have resorted to the use of a mediator, which has also failed. Now, it is after the second stage of mediation now that the first third party, external interference in the dispute is allowed. By this stage, the Minister of Labor can, upon receipt of a report of failure of settlement via collective bargaining or mediation, can now appoint a conciliator to settle the dispute. This is provided for in section 8 of the Trade Dispute Act. So the conciliator appointed by the minister has the mandate to settle the dispute within 7 days, after which the terms of settlement becomes binding on the parties. However, it is still possible that the conciliator failed or is unable to bring the dispute to an end. Then such conciliator will revert back to the minister, who shall take the next step. Now, the next step on the pyramid, as can be seen, is resort to the industrial arbitration panel. Now, the minister, upon receipt of failure of conciliation to resolve the dispute, can now refer the dispute to the industrial arbitration panel. The minister is empowered to set up an arbitration panel pursuant to section 9. Within this panel, then, an arbitration tribunal is constituted to take charge of the dispute and settle it. Now, if the arbitration panel is able to settle the dispute, the award of the panel becomes binding if not objected to by any of the parties on the parties. However, if the arbitration panel is unable to settle the dispute, either because one of the parties objects to the terms of the award, then the dispute will be referred to the National Industrial Court. But I should note that while the steps in the panel seem sequential, however, the minister has the power to skip any of the stages of settlement. The minister can, upon a report that mediation has failed, can take hold of the dispute and send directly to the National Industrial Court or to the Industrial Arbitration Panel without going through a conciliation. Now, let's talk about the National Industrial Court. As seen from the pyramid, at the top is the National Industrial Court, which has the exclusive jurisdiction with respect to labor, employment, and trade union matters. and created by Section 254A of the 1999 Constitution and the National Industrial Court Act. What is important, very important actually, is that the National Industrial Court enjoys both original and appellate jurisdiction in respect of trade disputes. However, aside from specific instances in the National Industrial Court Act and the Trade Disputes Act, as it will be seen in the course of this work, the National Industrial Court exercises appellate jurisdiction more than the original jurisdiction. This is because access or the jurisdiction of the National Industrial Court is subject to the parties exhausting the ADR mechanisms in the Trade Disputes Act. So the jurisdiction of the access to the National Industrial Court is not in all cases as a matter of course, complying with the steps in the pyramid is basic. It is when the steps have been exhausted that the parties now have access to the jurisdiction of the National Industrial Court, except in specific instances where specific statutory instances where the National Industrial Court can exercise its original jurisdiction. Now, the original jurisdiction of the National Industrial Court, let's examine some of the original jurisdiction, some of the instances of its original jurisdiction. One is found in Section 16 of the Trade Disputes Act, which allows the National Industrial Court to exercise original jurisdiction with respect to interpretation of collective agreement, memorandum of settlement. Then Section 15 of the same act confers original jurisdiction on the NIC with respect to interpretation of awards of the Industrial Arbitration Panel or the National Industrial Court itself. Also, Section 254 of 54C of the 1999 Constitution confers original jurisdiction on the National Industrial Court in respect of some trade union matters. Now, we'll still come back to the original jurisdiction. Let's go on to the appellate jurisdiction. As noted, the NIC takes appeals from the decisions of the arbitration tribunal. As stated, it is when the ADR mechanisms have been exhausted, where the disputes remain unsettled, that the NIC takes jurisdiction. It is naturally the NIC takes appeal from the Industrial Arbitration Panel, which is its immediate which follows immediately in the pyramid. From the pyramid, except instances when the minister apprehends the dispute in Section 5 of the Trade Disputes Act, the NIC will take appeal from the decisions of the Industrial Arbitration Tribunal. Why? Excuse me. Now, Section 7 sub 3 of the NIC Act validates the requirements of exploring ADR techniques contained in the Trade Disputes Act as stated for, and as can be seen from the pyramid, as it acknowledges that the National Assembly may make any law that will subject the jurisdiction of the NIC to exhausting arbitration and conciliation. So both Section 7.3 of the NIC Act, read in conjunction with the provision of Sections 4, 6, 7 of the Trade Dispute Act, shows that the NIC's access to the NIC is subject to exhausting the ADR techniques listed in the Act. So the very Act that creates the National Industrial Court, the NIC Act itself, validates the requirement of alternative dispute resolution. So now refer us to the case of Senior Staff Association of of SS, let me just abbreviate it, SSASCGOC, against the Honorable Minister of Labour and so on, that's decided by my Lord Justice Kine just about last month, where he reiterated the importance of exhausting the ADR mechanisms before assessing the decision of the NIC. Okay, in addition, I'll refer us to section 254C, 3 and 4 of the 1999 Constitution as amended, which empowers the NIC to establish ADR centers and to sit in appeals over them. So the Constitution also validates the requirement of, one, exhausting the ADR mechanisms before assessing the NIC, and secondly, pardon me, please, sitting over appeals from the Industrial Arbitration Panel. So I will state also that the promotion of amicable settlement of trade disputes is at the core of the Trade Disputes Act. Therefore, the parties are encouraged to attempt to settle the disputes by themselves, within themselves, without resorting to third parties. Because at the base of the pyramid, as can be seen, collective bargaining and mediation appointed by both parties are the very first steps that must be done by the parties. And it is very possible that the disputes are settled without third-party interference at all. So if the disputes are settled by collective agreement reached by both parties, the dispute becomes terminated. And it shows that the legal framework is reluctant to enforce or encourage third-party interference. So promotion of amicable, peaceful settlement of trade disputes is at the core of the provisions of the Trade Dispute Act. So both parties should settle the dispute between themselves through mediation, and these internal settlement mechanisms have been made mandatory on the parties. The processes of internal settlement cannot be skipped under whatever guise. Therefore, the NIC will cease to take over jurisdiction of any trade dispute that has not complied with the provisions, with the ADR provisions in the Trade Dispute Act. So it is until the third stage of the pyramid that third-party external influence is recognized or is allowed under the Trade Dispute Act. So it is at the conciliation stage that a third party appointed by the minister is allowed to enter into the dispute. So at the core of the settlement mechanism is peaceful, internal, collective, harmonious resolution of trade dispute. And this is highly commendable. Even though, like I noted earlier, that by virtue of provision of Section 5 of the Trade Dispute Act, a minister can apprehend a trade dispute at whatever stage. However, it is unlikely that a minister will apprehend a dispute at the collective bargaining stage, because at this stage, the dispute has not even been declared, and it is unlikely that the minister is aware that such disputes exist. I will refer us to a number of cases where the National Industrial Court has validated the position, showing that the steps in the pyramid, the ADR mechanisms in the pyramid are compulsory and are condition precedent to assessing the jurisdiction of the National Industrial Court. Also, to further buttress the fact that peaceful and harmonious internal settlement of trade disputes is important, The NIC has made provisions allowing the National Industrial Courts to depart from the rules of evidence if the interest of justice will be better served. So this shows that unnecessary technicalities may be disregarded in the interest of justice. So the focus of settling trade disputes in Nigeria is on harmonious, is geared towards promoting harmonious, internal, peaceful settlement of disputes, and ultimately the interest of justice being served and the interest of the parties, or both parties, being catered for. However, as commendable as the focus of the Trade Dispute Act, and by extension the NIC Act, towards promoting a harmonious trade relation, there's room for improvement with regards to some of the provisions of the Trade Dispute Act. One is that of course, the provisions on sanctions are inadequate and may not ultimately serve the true end or goal of sanction, which is either to deter or for punitive purposes. So it would be better if, for example, the fines are kept open with respect to individual offenders, so that open fine, and for corporate offenders, equity fine will have been more effective. So that is a recommendation. There's need for the fines, the sanctions to be moderated. Also, for corporate offenders, fines do not, the sanctions need not be financial. There may be other ways to punish, to sanction a corporate offender beyond fine. However, even fine as it is now, the amounts stated in the Act are ridiculous, so to say. And even if such amounts are changed, still, excuse me. Excuse me, please. I said there's a need for the fines to be amended to reflect equity fine for corporate offenders, and for individual offenders, it can be made to be in the form of an open fine. Also, the provisions of the Arbitration and Conciliation Act can be adopted to serve as a guide for the arbitration process. Now, let me just talk about some practical issues. Some nuggets on practical approaches to dealing with potential disputes. Once a dispute takes place for practitioners in this area, one is to adopt or resort to the internal settlement mechanisms discussed about earlier, through resort to collective agreements, mediation, and so on. I said in unionized environment, the collective agreements will usually provide a settlement mechanism at unit or plant level or at the national level. The second option will be to resort to the option of Form TD2 from the Ministry of Labor. So one is activating the internal settlement mechanism. The second is procuring the Form TD2, which will kickstart the process in the Trade Dispute Act, and the union will not be able to take further steps like strike. And if, for example, if there's a threat of strike after filling the form, then an injunction restraining the union from going on strike can be sought. Okay. So on more practical issues, I noted that dealing with unions requires a lot of patience and strategic planning. Also, that it is very important to try to build a relationship with the union so as to prevent and arrest potential conflicts. The goal is not to resolve conflicts per se. The goal is to have a safe, harmonious working relationship. The goal is not to allow conflicts to occur or to arrest conflict before it escalates. So having a good relationship with unions can help to anticipate and prevent conflicts. Then building relationships is very key for practitioners. Building relationship and have a working understanding of the mandate of the Ministry of Labor. I think that's just, I'll stop here.
Okay, so thank you very much, Dr. Kombi. We're just going to go straight, before we go into the question and answer session, I wanted to invite His Lordship to please give us any comments that he has. And also, we're waiting for Mr. Folabi Kutsi SAN, who would anchor the question and answer section of this webinar. But before then, while we're waiting, please, I wanted to ask His Lordship to give us any comments, because this is actually, dispute is actually the meat of, of what he sees every day. So I wanted to invite His Lordship to give us his comment at this time.
Thank you, moderator. Actually, a good deal of my comments were said on Friday on issues relating to trade disputes. And I tried to explain how, in trying to do away with some of the confusing definitions of concepts, we tried to change some terminologies within the context of the National Industrial Code Act. But of course, because the main laws that we propose were actually have not seen the light of day, we are still stuck with the old regime. While I commend the paper presenter, you could notice that at the initial stage, the presenter said something about in defining trade dispute, emphasizing trade. That's one of the hallmarks of the Court of Appeal decision that I complained about on Friday. Trade dispute is a collective term. You must look at it in its corporate state as a phrase. You cannot separate trade from dispute and get the definition of a trade dispute. Secondly, when we generally discuss the definition of trade dispute, we often forget or we refuse to emphasize, and I have seen this even in Supreme Court cases. If you look at USO and Unitoy Bank, the concurring judgment of Justice Ogumbi, where the emphasis was made that because the complaint was for retirement benefits, the complainant was no longer an employee. And because the complainant was no longer an employee, the dispute could not be a trade dispute. Now, if you go to the definition of trade dispute, you would see the emphasis is a dispute between employees and employers over the employment or non-employment. Those terminologies are used, employment or non-employment. You cannot discard non-employment. And I like to tell people that employment rights inure at 3 levels. There's what we call pre-employment rights. If you are an applicant and you apply for a job and certain things are done, I will give you a simple example. You are told because you have HIV, you cannot be given the job, even though you are qualified. You can found an action in relation to that pre-employment right, which is your right as an applicant not to be discriminated against. Secondly, there are employment rights, rights that inure to you while in employment. And then lastly, there's what we call post-employment rights. And one of them we are very familiar with is pension. So, an analysis that says because you are no longer an employee, a dispute over pension, over retirement rights is not a trade dispute. Don't forget, even within the context of trade unionism, we have the Nigerian Union of Pensioners, which means the law recognizes that they are a force to be reckoned with, and they have rights that need to be safeguarded. If you go to the Constitution and you read some decisions by especially Justice Onogen before he became Chief Justice of Nigeria, you would see how he lamented about the discard of pension rights of people who have worked themselves through the ages and are now being abandoned. So when you now say a dispute over pension rights, a dispute over retirement benefits is not a trade dispute because the complainants are no longer employees. For me, it is not a proper understanding of the concept of trade dispute. So sometimes, yes, Court of Appeal, Supreme Court, these are courts that their decisions cannot be questioned and so on. But yet, we must point out how wrong those decisions are so that at the next opportunity, those decisions are going to be factored in, are going to be taken into account and so on. So I just want to emphasize that we have to be very careful how we understand this concept of trade dispute. And more importantly, since the third alteration, we also need to be very careful our reliance on older judicial authorities. I read one of the questions, somebody was complaining that the presenter was only citing NIC cases. NIC cases are not decisions of other. There are, of course, other decisions. On Friday, I alluded to 2 Court of Appeal decisions that appear conflicting. One said inter and intra-union disputes can only come to NIC in its original jurisdiction. The second one, 2020, in Makudi said, no, even inter and intra-union dispute must go through the dispute resolution processes of Part 1. But I want to advise lawyers. There is something I have seen over time, and that is lawyers have this penchant. Let's avoid the dispute resolution processes and go to NIC. Even things that are triable, even things that the facts are contentious, they manage to package them as originating processes issues. And then they bring them and says, we are looking for declarations, we are looking for injunctions, which IAP cannot give, and so on. In fact, not too shortly before the program started, I had the cause to advise a senior advocate who came visiting me in the office. I said, see, sometimes when you have a problem, go to the Ministry of Labor, talk to the minister. He has powers to bypass all these processes and send the matter to NIC. If you show him an urgency in respect of a trade dispute, in other words, the urgency is such that you don't want to go through conciliation, mediation, arbitration. Once he sees the urgency in the matter, he will be prepared to send it straight to NIC. It is all part of the dispute resolution processes that we are talking about. He can bypass mediation and conciliation and send it to IAP. He can bypass IAP and come down to NIC. It all depends on how you present your case and how urgent the resolution is required. For a last point before the questions, the presenter talked about 2 types of disputes, individual and collective labor disputes. That is perfectly correct. But there's also another classification, what we call the disputes of rights and the disputes of interest. Disputes of rights are disputes over rights that have crystallized. Somebody is not paying you your salary, which you have already agreed on. The dispute over that is a dispute of right. And very often, they are not the kind of disputes you go through conciliation, mediation, and the like. They are disputes you simply go for adjudication conceptually. Disputes of interest are when workers are interested in creating rights. You want a pay rise. Your employer says, no, I'm not doing. So you go on strike over the necessity to do pay rise, the kind of thing you find ASU doing with government now. That dispute is one of interest. Now, there is a little catch here. The ILO believes that the right to strike is a right that inures only when the dispute is one of interest. In other words, where a dispute is one of rights, you don't have the right to strike over it. You are expected to simply walk to a court of law and have it enforce your right. But when you want to generate a right, that's the dispute you can go on strike on. Unfortunately, under the 2005 Trade Unions Amendment Act, when President Obasanjo was president of the country, we had a reversal of this conceptualization. If you go to the 2005 Trade Unions Act, you are going to find that workers cannot go on strike unless the strike has to do with a dispute of right. In other words, we have changed principle. We have like upturned the order of principle. Why ILO says the right to strike is only when the dispute is one of interest. In Nigeria, statutorily, the right to strike only operates when there is a right, which for me, it's wrong. But of course, that's a statutory provision and which as a court of law, you have to apply. But sometimes at discussions like this, you point them out that, look, sometimes we change principle and upturn it on its head. And consequently, you sometimes have the kind of problems we have in the workplace. Even matters as of rights, you will discover, like, I think one of the complaints ASU is making is that, oh, we signed an agreement long ago and you are not doing it, so we are going on strike on that. So some of these things are distorted because we sometimes apply in practice some of these rules upside down. Thank you.
Thank you, Your Lordship. Okay, so we'll just quickly the question. Let's see, Mr. Falabi, are you on now? Okay, so while we're waiting.
Very good afternoon, Inter. I am still in transit. I am hoping that I can. So please, if you can take the first two questions, I would join by the time Dr. is done with that, and I'll be able to follow up on the other questions.
Okay, so the first question is, where a dispute is referred to NIC from an award of IAP, does the NIC thereby exercise original or appellate jurisdiction in that instance? Dr. Kombi?
Yes, when a dispute is referred to the NIC for interpretation of award, the NIC sits in its original jurisdiction. If it's a question of interpretation of award, the NIC sits in its original jurisdiction.
Okay.
Can I add something here?
Yes, Your Lordship.
A dispute over the interpretation of an award of IAP is considered a fresh dispute. A fresh dispute. I had an experience. I don't know whether I have time to relate it. It's a fairly long one, but very funny. And it showed how creative sometimes we can be at NIC. Shortly before the civilian dispensation of 1999, May 29, if you remember, those of you who can remember the history of the Decree 4 of 1996, which banned and unbanned unions and all that stuff. If you remember vividly, there were series of decrees that were made. And here was this matter that came to us at NIC. And because it came to us, we decided it, but unfortunately, we relied on an instrument that we did not avert our minds to, was already repealed. So we gave a decision that was strictly speaking per incuriam. Now, we have interpretation jurisdiction to interpret our own decisions, including IAP awards. The union did not come until after May 29, by which time the constitution we currently operate was in vogue, was already in operation. They now filed an action by way of interpreting this wrong decision we gave, asking us to overrule ourselves because at the time we decided that case, we relied on an instrument that was repealed. In other words, an instrument that was non-existent. Now, this is where the story gets nicer. As at 1999, when General Abdul Salami was handing over, some decrees were repealed. Now, in repealing decrees, this instrument we relied on for this decision was reactivated. So it was now the law under the 1999 constitutional dispensation. So here we were being asked to review a decision that we made was wrong because it relied on an instrument that was not existent. But we are being asked to review that decision at a time when that instrument was now law because it has been reinstated. So we reasoned, one, under, I think, section 18 or so of the Trade Disputes Act, either 18 or 19, there's a provision that says the interpretation of an IAP award is a fresh dispute. But there's no corresponding provision that says in interpreting NIC award or decision, it is also a fresh dispute. So we felt by analogy, the rule that applies to the interpretation of IAP award must equally apply to the interpretation of NIC award. So we now held that if this second suit asking us to interpret our award is a fresh dispute, it means we must apply the law as it is today. You know, the law is that in resolving a question or a matter, the law to be applied is the law as at the time the cause of action arose. So in filing for interpretation, the law to be applied was the law post 1999 Constitution. And because under the 1999 Constitution, the instrument we relied on was now law, there was no talk about us declaring that original case we decided per incuriam as wrong. Because today, under the current dispensation, that instrument is law, and consequently, in this new case, what we said some years ago was correct if you take the law as it is today. I said there was an element of creativity here because you are not going to find any statement in the Trade Union, in the Trade Disputes Act saying that NIC, when interpreting its decision, is a fresh dispute. But because we had that provision relating to IAP, and because we take appeals over IAP, we felt that by analogy, I know many people are going to say we were wrong, but there was a little bit of expedience here. If we had said what we did was per incuriam and set it aside, the following day we are going to get the same action filed. And we are going to say the same thing we said was per incuriam because now it is no longer per incuriam. So sometimes at NIC, we are faced with this kind of choices, value judgment really. And we have had once in a while to improvise to be able to sort out some of these knotty issues.
Thank you, Your Lordship. So we'll just go to the next question. To what extent can a decision reached by the union, to what extent can a decision reached with the union by management against the express word of the collective agreement signed with the management bind the affected staff who did not participate nor was invited at the meeting? What happens where the staff affected is not a member of the union, strictly speaking?
I think the question is not clear. If I can look at it from two limbs. First, if I'm right, it said, to what extent does a decision reach between the union and the management, which is different from the terms of the collective agreement? Is that it?
Yes. No.
Now,
so against
decision reach between the union and the management, I should go on, different from the express terms of the collective agreement. A decision reached between the union and the management is actually a collective agreement too. You understand? A decision reached between a union and the management is actually a collective agreement. So maybe the question needs to be rephrased. But if the second arm to the question is, can an employee who is not a member of a union be bound by, is that it? The second leg, ma'am?
Yes,
An employee who is
not a member of the union, strictly speaking.
No, if an employee is not a member of a union, he's not bound by whatever agreement the union reaches.
Can I clarify something here?
Yes, sir.
I agree with the presenter that that question is not very clear, but I have a sense of what the questioner wants, and it will help me explain something I have seen a lot of lawyers disregard. The unionization in Nigeria is according to, we have what we call industrial unions, and then we have senior staff associations, and we have employers association. The senior staff associations are meant to follow the pattern that the industrial unions, which is generally for junior staff, follows. So if you have a non-academic staff union, for instance, the variant will be ASU. If you have NUPENG in the oil industry, the variant will be PENGASN. So the jurisdictional scope of NUPENG, which is indicated in the Trade Unions Act, PENGASN is supposed to follow like that, but for senior staff. But we have held over time, and we have not changed our stance, that when it comes to unionization of junior staff, eligibility is the yardstick. And because eligibility is simply the yardstick, we believe that junior staff are automatic members of unions, so we don't require proof. But for senior staff, the law is that they must indicate individually and in writing that they want to be. And this is where the problem comes in. I have done a case where the man joined as a junior staff. So he didn't need to prove to me that he was a member of a union, because as a junior staff, he's deemed to be a member. If he does not want to be a member, he can on his own, individually and in writing, write and say, I no longer want to be a union. But the law deems him to be. While the man was in office, he got promoted and became a senior staff. Now he is laying claims on the basis of being a senior staff and relying on a collective agreement. And for us in NIC, once you are a senior staff and you are relying on a collective agreement for purposes of making any claim, the first question we look through your pleadings, have you pleaded membership of this union? Because if you don't plead, we don't assume you are a member. Because as a senior staff, the law does not assume you to be a member of any union. You must yourself write and say, I want to be. So you must prove that you are a member. Now, how do you prove membership? Either you show us your ID card or you show us a pay slip that shows that union deductions have been made from your salary, or you show us a letter or something you signed to the union saying, I want to join. And this thing is very important because part of the crisis we are seeing in the world of work today is because of this misunderstanding. As a senior staff, an employer has the right to say, I am not going to deduct anything until I see you formally write to me and say, I am a member of this union. So in other words, it's not automatic. You don't just carry, you don't hold people to ransom. That because you are a senior staff, you are automatically a member. No, it's not. And this leads me to the very key point. If you are a senior staff and you are relying on a collective agreement to make a claim before any judge in the National Industrial Court, you must plead your membership. And you must prove it. And we held that membership is proved by reference to an instrument, to a document. If you say, for instance, in your pleadings, I am a member of this, I'm a member of PENGASN. Sorry, let me use that as an example, since that is a senior staff association. I am a member of PENGASN. And in the defense pleading, the defendant says, yes, I agree, he's a member of PENGASN. That is not even sufficient for us because membership is not proved by admission. Membership is not bestowed by an employer. You must show that you are a member by pleading it and proving it. And proving means reference to a document. It cannot be conferred by an employer. It cannot be conferred by pleadings or by admissions in pleadings. So that bit of the question saying whether if you are not a member, you can derive a benefit. Our system here in Nigeria does not recognize what they call the most representative system. In other systems where trade unionism works, what they do is the kind of freedom you are allowed, you can form 10, 20, 30 different kinds of union within a small establishment. But the only body that is allowed to negotiate is what is called the most representative union, the union with the highest number of members. Now, those of you who are not members of that union, if you want to derive the benefit of that collective agreement, you pay what is called an agency fee. In other words, there is no freeloader. The concept of free rider or freeloader is not there. You must pay something they call an agency fee to enable you to take the benefit of any collective agreement that was agreed on. Like I said, in Nigeria, we don't have that system. And because we don't have that system, what we have is simply a chunk that says, okay, in the oil industry, Pengasin is the umbrella association of all senior staff. While you have the right to join, it means if you don't join, you are not a member. And if you are not a member, you cannot come to NIC and say, I am claiming the benefit of this collective agreement that was, even if the employer chooses, and I say this advisedly, even if the employer chooses to pay you those benefits, because we have seen instances where employers pay extra to workers who refuse to unionize to encourage them. And we usually say, there's no problem to that until problem arises and you come to NIC. If you come to us and you say, I have been paid my salary, my allowances, everything based on this collective agreement, so I am making my claims based on that, we should tell you where is proof of membership. If you don't have proof of membership, you are not going to get any verdict from us based on that collective agreement. So while you have the right not to join a union, be careful how you exercise that right, because the repercussions tomorrow may be too much.
Okay, just before we move on, because of interest of time, Mr. Kuti, are you there? Or I can still go on. Okay, I guess I can
kindly
still
proceed.
go.
Kindly proceed here.
Okay, so another question is, going by your reference to obtaining of an injunction restraining a union from embarking on a strike, under what circumstance can a union that has followed due process before threatening to strike be restrained from such a strike? By injunction? Will such injunction be legal?
Can you come again?
Okay, so going by your reference to obtaining of an injunction restraining a union from embarking on a strike, under what circumstance can a union that has followed due process before threatening to strike be restrained from such a strike? Is it by injunction? Will such injunction be legal? Did you get the question?
I'm a bit confused.
Okay, Your Lordship, did you get the question?
I got a bit of it. Let me say this. I always advise, a union says we want to go on strike. They threaten the right. Usually the law, there is a procedure for you to go on strike. The normal percentage of votes you have to get for it from your members. You have to give how many days, 15 days or so notice and all that stuff. So this period, you file and write to your employer on so day, if you don't do X, Y, Z, we are going on strike. What we have seen is that some employers will simply wait until the strike starts. Then they file an ex parte motion, tell us everything about how urgent it is and so on. And usually we say, look, when was the notice to strike given to you? It was given 1 month ago and you sat at home. You did nothing until now and then you are telling us it's urgent. No, go and put the other party on notice. The point I'm trying to make is this. If there is a threat to strike, but the strike had not yet commenced, an employer can come by way of ex parte motion and get an order stopping that strike. But if the strike had commenced, we usually insist on you putting the other party on notice before we can give any order to stop the strike. Now, and this is very important, by law, we are not even supposed to make any order, because the moment any of the dispute resolution processes is activated, the strike is supposed to be called off by law. In other words, you don't even need to wait for an order from NIC. So let's assume the strike had even commenced and you come and file an action in NIC. The moment NIC says of that action, both parties are supposed to halt whatever they are doing. The workers are supposed to stop strike. If the employer had locked out some workers, he's supposed to recall them, because now the dispute resolution processes have been activated. But what we see generally is a general disobedience of even this. I've seen instances where myself and some of my colleagues have made innocuous orders that are by law what we should make, and the press have taken us to cleaners. How we have been bought. In fact, on one occasion, we were told to have sold a black market injunction and all that stuff. We've seen it. But principally because a lot of people don't even appreciate what the law says. Once the dispute resolution process is activated, even if it is conciliation, let's assume that issue of strike was reported to the Minister of Labor. And the moment he sets that machinery in place by setting up mediators, the strike is supposed to be called off immediately until those processes are concluded and the matter is resolved in that regard.
Thank you, Your Lordship. We'll look to closing the session. Sorry, Dr. Akombi, did you want to say something?
Yes, sir. Thank you, Your Lordship, sir. I was just going to add, in addition, that going by the provisions of Section 18 of the Trade Disputes Act, I do not even think it's very practicable to have a legal strike, so to say, because I believe the conditions in Section 18 are too restrictive, that it's almost like impossible to really have a strike that is legal, sir.
Yeah.
What's your opinion on that, sir?
That's one viewpoint that has actually, I've read quite a number of writers. Like I said, depending on how you want to look at it, the strike itself is a dispute resolution process. A lot of people don't seem to understand it that way. The strike is not just flexing modules. It's also one way of resolving disputes. Now, yes, I quite agree that the moment you go for conciliation, you are supposed to stop the strike. I agree it is highly restrictive, but the alternative question, if you don't do that, what do you do? Okay, take the current ASU federal government stand off. The warning strike finished, it's been renewed. So what next? For about 3-4 months, each side is at its own corner. Assuming any of the dispute resolution processes was activated, the strike would have to be called off because that's the basis to resolving it. But of course, it looks like both parties are not even sure of those processes. Because if they are sure of the processes, one would have activated it anyway. So yes, it may appear that once those processes are on ground, you cannot longer go on strike. And I need to also make a very critical point here. And maybe this is why some of these things go the way they are. I think under section 42 or 43, you know the rule about no work, no pay. Now, there's nothing wrong, even at the ILO level, to say strikers are not going to be paid. What traditionally happens is that each union is supposed to have what is called a strike fund. Part of the checkup dues you collect over time, you are supposed to dedicate part of it to a strike fund, and which is an investment that yields, so that when you are involved in a strike and to be able to enable workers go for the long haul, it is from the strike fund that workers are paid. And that's why the ILO sanctioned the no work, no pay rule. But in Nigeria, we don't have any strike fund. That's the plain truth. And that's why even when you call off a strike, you are struggling to enter into an agreement that says there will be no victimization of anybody who embarked on this strike and so on. What point am I trying to make? Yes, it's difficult to say that a strike, right to strike will exist with something like Section 18. But even the right to strike, are we doing it as it should be? So you find here both sides are really not even doing it according to the law itself. So we are having problems at that level. At the statutory level, we have rules in the statute which appear to frown on strike, but even those who strike are not doing it the way it should be done. Because strictly speaking, if you want to take the law of strike to its logical conclusion, tell me which union in Nigeria has a strike fund. At least I'm in a position to know. I have not seen one.
Okay, so we'll just go to the next question. I think the question on must inter-union disputes follow the mediation, conciliation, and AIP procedure? NIC could be invoked. I think His Lordship has answered that question. Palabi, sorry. NSF, did you want to say something?
Oh, okay. Well, sorry, can you hear me now?
Yes, we can hear you.
Fantastic.
Yes.
Well, I think I caught the last part of my Lord's very lucid and illuminating explanation on the bit about strike not being perhaps seen within the right context as should be. And he was actually going to perhaps ask my Lord to explain further that bit about the strike, especially seen within the context of the, let's say, the Trade Dispute Act, and the need to, if possible, reconcile it with the corpus or the understanding of the ILO literature, which regularly it appears that the industrial court, and for good reason, seems to apply or favor more in giving an explanation on that right to strike. And I'll give a particular example for additional context. My Lord, it appears that even that right to strike or strike in itself, maybe not expressly worded along that line, or the literature here not sufficiently adaptable in that sense. But the right to strike in a number of judgments that I know your Lordship have participated in, especially when federal government had gone to court to stop a strike action being embarked upon by NLC and TUC. I recall the one about the fuel subsidy in about 2016. And there was this interesting, I remember that was, for me, that was even the first time I think I had to relate with that. The court says the right to strike in itself, which appears was stretched, is a negotiation tool. So that action didn't succeed. And some of the explanation my Lord made today, I think is really bringing it home. Strike is seen as a negotiation tool within the ILO context. the right to strike is in itself seen as a negotiation tool within that context. That is, I remember that in that decision, the court had held that even though what they were demanding cannot properly be situated as a trade dispute. And every time you look at the legislation, the Trade Dispute Act, strike, it is usually, there's a correlation. But in that decision, my Lord had said that the contention then, which was an agitation about fuel subsidy and all of that, and then NLC asking workers to go on strike, cannot be situated within as a trade dispute. But notwithstanding, they had the right to strike as a negotiation tool. It's quite lucid when you see it from the ILO context, but the question I ask is that the legislation, the Trade Dispute Act, when it's brought into context, can we say that there's a correlation? That's on the one hand, my Lord. Before, personally, I will allow my Lord to go away with that, the analysis my Lord has made today about no work, no pay rule. My Lord, I would personally say that is some area that increasing perhaps grapple with. And then the particular, what appears to be an area that needs a little more clarification relates to that no work, no pay rule. The way it's interpreted, we need the ILO context, and understandably, because my Lord has rightly said there is a fund that takes care of the striking workers. We don't have that here. In a few of cases has been applied that, okay, it is self-executory to the extent that the employer can decide to pay or should pay and not seen strike as a means of penalizing workers. So, my Lord, if it is possible to also perhaps offer shed a few more light around that. There's no doubt, very illuminating and
SM Falabi, your internet service is really problematic.
I think he's on the road. Sorry, Your Lordship, just for the sake of time, I wanted to find out, I wanted us to agree on how long we're going to add, to this, because we're...
My Lord. Oh, my Lord. Oh, okay, my Lord.
So, well, it's up to you. I don't have any problem with adding more time.
Okay.
It's up to you as organizers.
Okay. Let's see. How much time do you have? I wanted to say we could stop at 4 p.m. because there were complaints from the last time, couldn't go to the mosque or something, but I think that's we've passed that time.
Okay.
So we could just go till 4 p.m. and close from there, right? Or 15 minutes.
You can continue. I very well noted, Isabel. Let me say that maybe you should continue, as I'm still struggling with the connection and hearing clearly here. So maybe I should just leave it for you to continue.
Okay. So in that case, Your Lordship, we'll just add 15 minutes to the clock and we will end at 3:45.
No problem with me.
Sorry, sir?
No problem with me. It's okay with me.
Okay. We'll just, I think we won't be able to take all the...
There are issues the XAN raised. I think one to do with no work, no pay, and then the other had to do with this right to strike for fuel increase. Let me start with the no work, no pay. What we have done at the National Industrial Court is that if an employer wants to insist on no work, no pay, of course, he comes to court and he insists on it. And then we look at the merit of the case and decide on the merit. But if after a strike, like it happens in one of the cases I handled, I think in Oyo, there was a strike between the workers in Oyo and the government in Oyo State. After the strike was called off, they signed into an agreement, and government agreed that they were going to pay the salaries of workers for the period that they were on strike, only for an action to be filed, and we were asked not to give an order that the government should not pay that money. And we said no. The agreement to pay strike pay is a fresh collective agreement, which you must obey. If you did not want to pay, you shouldn't have signed that agreement. So we refused to make the order. The other point regarding the right to strike where fuel increase is raised, the case in issue, I think it was a 2017 case. Fuel price had been increased and workers went on strike. And the issue came to us to decide on the legality or otherwise of the strike. The first hurdle was how the matter was framed. They came by way of originating process and they raised questions. If I remember vividly, the question was simply for us to determine whether a strike over the increase in fuel was a trade dispute, particularly following the Supreme Court decision in Nigerian Union of Electricity Employees versus BPE. Now, it's not worded like that, but I can vividly remember it was around that theme. The first problem with this case was, by the third alteration, Nigerian Union of Employees, Electricity Employees versus BPE was effectively overruled, because that particular decision was decided on the basis whether privatization, a dispute over privatization, was a trade dispute. And it was held that it was not. And then, of course, Justice Chukwumaene then went to town about how NIC is not a superior court of record. If it wants to be one, it needs constitutional amendments specifically and directly and all that. So the moment the third alteration was passed, National Union of Electricity Employees versus BPE was no longer good law, at least for most of the things it decided. So when a case was filed over the question whether a strike over increase in petroleum, the price of petroleum product is a trade dispute, in accordance with a Supreme Court decision that was no longer effective, given the third alteration, that was the first problem regarding that particular suit. But having raised that point, we went to the main issue. Given the third alteration, with NIC's power to apply international best practices and apply conventions ratified by Nigeria, two of which are conventions 87 and 98, is it legal for workers to go on strike in respect of increases in price of petroleum products? It meant having to look at ILO literature on the right to strike. And ILO has this world of literature regarding what they call the right to strike for political, social, and economic reasons. Having gone through the literature, what ILO says is this: where a governmental policy, socio-economic policy, has the tendency to affect, in general, the welfare or well-being of workers, the workers have a right to strike against that policy. And the question was, within the framework of the right of the increase in fuel price, don't forget, like I said, it was fought on originating summons. So the decision was based on the affidavits that were presented. But I remember vividly, because I did the case, in holding that within the context of what was brought, the workers had a right to go on strike for the increase in fuel, given the ILO literature on Conventions 87 and 89. Of course, by the time we were hearing that case, if you remember, I think the 2005, the strike that Adams Oshomole led when he was NLC president in terms of increase in fuel. That particular case, if you remember vividly, I think it first went to Justice Gumi, who was then CJ of FCT High Court, who held that workers have the right to go on protest, to protest. It went to Court of Appeal. Court of Appeal said Justice Gumi didn't have jurisdiction over the matter, so they remitted it to Federal High Court. It went to Federal High Court. The then CJ, I think it was Justice Ukeje, who now decided that I think NLC led by Adams Oshomole and co did not have a right to go on strike. So the matter went to Court of Appeal. I really don't know what Court of Appeal decided, but when I was hearing this matter in 2017, there was a preliminary objection that was raised that that matter was before the Supreme Court. And because it was before the Supreme Court, I do not have jurisdiction over this particular one, and so should not decide it. I should decline and wait for Supreme Court decision. I remembered asking counsel in open court that if somebody slaps you in 2005 and you are litigating that slap, and in 2017 he slaps you again, will you not litigate it? Will you wait for the 2005 slap to be reconciled or sorted out before you can talk about the 2017 slap? Anyway, I held that I had jurisdiction. It was a fresh cause of action, has nothing to do with the 2005. The issues may be the same, but the cause of actions are different. I assumed jurisdiction and then, of course, decided it on that basis that there is a right to strike when it comes to increase in fuel price because it affects the general welfare of workers who, at the end of the day, based, of course, on the affidavit evidence that was before me, indicated or showed that they suffered losses and things like that. Yes, moderator.
Yes, thank you, Your Lordship. I think I would say that you have you and Leonard Silk have actually talked about taking all the questions that as it relates to strike. So we're not going to go on any, we're not going to take any questions that relates to strike because I want to believe that, all of that has been captured. Dr. Kombi, do you have any opinion to add to that? As in, do you agree that we've at least answered all the questions that as it relates to sorry, Leonard Silk, what did you say?
Okay. Yes, thank you very much. I absolutely agree. I just thought that there's a question that has been asked that I think it would be good to have my Lord's thoughts, and then Dr. Akombi, where possible, to not on strike. I agree with you that we should move away from strike, and let's look at redundancy. My Lord and Dr. Akombi, I would like to have your thoughts on this. Someone has asked, and I think this is actually a very good question, especially in relation to redundancy, or the law relating to redundancy in Nigeria. The question says that under the Nigerian law, redundancy is defined by Section 20 Labor Act, and it does not provide for a detailed procedure to be adopted by employers in cases of redundancy, calculation of severance benefit. Calculation, can we speak on this aspect of the law? Well, the question has been posed that can we have your thoughts on this aspect of the law? And I think it's basically to do with the test or the bare lettering without explaining or giving a full explanation of what's the procedure beyond saying that, first in, last out, and then engage. So I would like to have Dr. Akombi's thoughts, and then for my Lord in particular, what would be the position in non-unionized organizations and for workers who arguably will still, I mean, the debate is still out there, or the jury is still out there. The Neighbor Act does not apply. So those in the executive managerial position, for example, in declaring or in bringing the employment to an end on account of redundancy, what exactly is expected to be done? Dr. Akobi, and then my Lord can.
I'm sure doctor will go first.
Okay. Yeah, yes, doctor should go first. My Lord, we are waiting for clarification in relation to organizations that are non-unionized organizations.
I seek to be guided by my lordship, sir.
Yes,
Doctor,
asked the question and said, "You go first."
I perfectly understand your position, and I.
But if you want me to go first, there's no problem.
Yes.
Yes, sir.
No, maybe doctor is conceding that my Lord should just take the whole answer.
You see, when it comes to redundancy,
the
only statutory provision we have is Section 20 of the Labour Act. Unfortunately, it cannot help you. All it says is consult. And once you consult, you have met Section 20. This is where we expect for us as adjudicators, creativity from lawyers. The third alteration has given us a leeway now. Formerly, we didn't have the leeway. Today, we have it. Apply international best practice. What we do right now is, first and foremost, there are some organizations that have gone the extra mile to make copious provisions dealing with redundancy, how it should be treated if disputes over it arise. Once provisions like that exist in an organization, we respect it and we interpret it, of course, subject to the rule that where there's ambiguity, we resolve it in favor of the employee. Now, where organizations don't make those detailed provisions and there's a problem, this is where we expect counsel to the claimant who is complaining, for instance, to say, okay, while the Nigerian system does not have detailed rules, this is how other jurisdictions have treated it. And we are urging the court to apply it based on its jurisdiction, to apply best practices. Now, the defendant, of course, will have the opportunity to say, no, you only gave us examples of 3, 4, 5 countries. In these other countries, this is how they are doing it, which is in opposition to what you do. So once the court has the advantage of these counter arguments, then, of course, in its own wisdom and based on its own sense of justice, it will then adopt something that it thinks resolves the dispute in question, either for or against the complainant. But this is like outsourcing. This is another area that we require specific statutory intervention. If we don't get that, then we are forced as a court, again, to resort to this case-by-case way of resolving some of these things. And that, again, would depend, like I said, on the quality of legal representation that we get in terms of the issues on ground. Doctor, over to you.
Yes, I agree with you, sir, of course. And I'll just add that I believe it's more for practitioners in this area to test this very aspect of the law, since we understand that the legislation is quite limited. So we hope practitioners like SAN, Kuti will test this, and when this is very tested in the courts, maybe through judicial activism, we'll have, if the lacuna in the legislative process is yet to be met, through judicial activism, we'll have like a framework for calculating redundancy and all that.
Thank you very much, Doctor, and then my Lord, for the very incisive responses given in relation to that. If I'm allowed, and I note that this is also about disciplinary procedure, the question around that will relate to the rationale or the propriety of the National Industrial Court's position that an employee who is perhaps facing a disciplinary procedure and desires to just turn in his letter of resignation, knowing fully well. And I take, for example, someone in a very sensitive, volatile sector of the economy, like the banking or financial institution. And whilst undergoing or facing that disciplinary procedure, he turns his letter of resignation that he wants to go. And the industrial court has ruled, more like the rule in Ngbeti's case, drawing from the notable case of Ngbeti and Unity Bank, where the court said the provision of the handbook of that particular bank, or indeed any similar provision in any handbook that restricts the movement or says that such an employee in that circumstance cannot put in a resignation, would amount to forced labor. The rationale has been explained in those other cases. My Lord, the pointed question today is not so much about the rationale as seen from the perspective of that employee who says, I want to go, I've decided to go, or this is the time I decide to go, and for which the court says there's a constitutional provision that there can be forced labor, and then there is also ILO convention. But still balancing the rights, In what way or measure as the industrial court thought of or provided for the employer? Take, for example, like I said, in that sector, say the financial sector, where employees, they can, that sort of infractions, financial and related cases come up regularly. If an employee knows that, well, I can decide to go and steal 100,000 and then let them be investigating me and turn in a letter of resignation, how is the employer protected? My Lord.
Like I said on Friday, firstly, by leaving immediately, there are benefits he's not entitled to. Secondly, by leaving immediately, he opens his flanks for tomorrow what would look like negative references. Because if you were to ask for a reference and the employer writes, look, we investigated him, but he left, so we had to allow him go. That's suggestive of wrongdoing in itself. But in terms of what immediately inures to the employer as a benefit, you also have to look at it relative to the, in quote, the intrinsic value of saying you are dismissed. If an employer dismisses in some circumstances, apart from that intrinsic value, there's nothing coming to him. The same benefits that usually in dismissals you are disentitled are the same benefits that you are to be disentitled if you were to leave with immediate effect, except of course, like I pointed out, earned benefits. For instance, if he had worked and for the past 2 months you did not pay him his salary, of course he's entitled to salary for those 2 months. The law, we know it as of dismissal, is that even those ones you can't claim. But that's not really the issue. And then it used to be that because there was a pension scheme, you forfeit all of that. But now with the contributory pension, you cannot stop, because contributory pension today is looked at as earned income. The deductions have already been made and remitted to a pension fund administrator. And the employer has no control over that fund, so he cannot even stop it. So yes, it may appear as if the employer does not have some benefit, but I asked the question, what was the benefit when he had the right to dismiss, other than just that intrinsic satisfaction that I dismissed him instead of allowing him to go?
Very well, my Lord. Thank you very much, my Lord. Dr. Akombi, I don't know if you have additional thoughts.
Dr. Kumbi has stepped out. I think she went to do something.
Fantastic.
So
yes.
Yeah, we have 10 more minutes. So if you wanted to wrap 10 more minutes.
Okay.
We
have
10 more minutes.
Okay, fantastic. Then let me just quickly go straight to two questions asked here. My Lord, a question has been posed specifically that what is the validity of a clause in an employment contract preventing an employee from going to court in the event of a dispute?
If it's an absolute provision, then it's an unfair labor practice provision. Yes. But if it is contingent on something happening, it will be respected, just like pre-action notice.
Yeah. Yes, my Lord.
If it's absolute, if the provision is absolute, that you cannot go to court, of course, we are going to come down on that provision as an unfair labor practice provision. But if it is contingent on you doing certain things, maybe following an appellate process through, then of course, we simply interpret it as your right has been suspended until you sort out all those things, then you can come to court. But like I pointed out on Friday, we were able to rule as vindictive and malafide the denial of promotion and the suspension of a staff because her family went to court. And we felt as a question of value system, we cannot as a court acknowledge that an employer can deal with you, discipline you for going to court. But if the provision simply says, don't go to court until you do X, Y, Z, when you come to us, we'll say you are coming prematurely, go back and finish it and then come.
Yes. Thank you very much, my Lord. Thank you very much, my Lord. Well, one last one from me, which I think I would like my Lord to probably just try and share his thoughts as well, will be on the question of still on disciplinary procedure. My Lord, from the line of decisions from the industrial court, I mean, quite a number of eliminating decisions around that, it does appear that the takeaway is that the handbook of every organization, work entity must be specific or try as much as possible to define what is acceptable in the workplace and what is otherwise frowned at. And I recall that at every point in time, my Lord's decision in Director of SSS, Valola, Director of SSS, to the extent that wearing tattoo to work, there is nothing wrong with it as long as the handbook has not defined or specifically engaged, made very clear and what it means to, how it means to appear, to dress to work and all of that. So the question now is that, considering that at the end of the day, unfair labor practice has always been interpreted in light of question of facts, is it possible
have we lost you?
Frowned at, or all what would not be acceptable at work?
You have to repeat it. You have to repeat
Hello, my Lord.
it.
Is it possible? Yes, my Lord, is it possible to have a handbook? So, which is basically, I mean, coming back to the court to perhaps try to accommodate again from the perspective of the employer. Is it possible to have a handbook that can, to a very large extent, and this?
We've lost you again.
Certain acts or certain practices that would be frowned at when it's committed by the employee. Because I know that very much before the industrial court came, what most handbooks used to have misconduct, gross misconduct, and it is usually left for the employer to, after going through the disciplinary procedure and all of that, or process, to come to conclusion whether the particular act or inaction is such that would be classified as a misconduct for which disciplinary action can be taken. But in today's world, it does appear as if there's a need to now revisit the handbook to almost make it like a Bible, voluminous, defining everything that will not be accepted or that will be frowned at the workplace. So the question is it possible to do that? And is the industrial court considering perhaps leaning to still accommodate in the perspective, from the perspective of the employer, without necessarily having to thumb through what is expressly stated in the handbook.
Leonard, there's something problematic with how you put it.
Yes, my lord.
The very person who made the rules,
yes, my lord,
is now being given the leverage and the latitude to determine what is gross misconduct without indicating what it is. Don't you see that the opportunity for absolutism is higher? If you allow an employer who drafted the rules to still determine based on his own subjective criteria the content of gross misconduct, don't you see that there's a problem inherent in that itself? Part of the problem is this. I've seen instances, for instance, where employees are queried for one thing and found guilty of another thing. The employee is given a query. He answers the query and they say, come to disciplinary process. At the end of the disciplinary process, the report says he's guilty of something else. And for us at NIC, we have said, no, you can't do that. The query you gave has to be what you do through this. If you find something new, you have to start the process all over by giving him another query, let him explain, then go through the process. I have complained in some of my write-ups, and I think in some of my decisions, I have made that point. I'm not too sure about decisions, but write-ups, I'm certain. I've complained about the absence of labor standards auditing. It's supposed to be one of the functions of the Ministry of Labor, where they ought to be able to look through organizations and see how their conditions of work, conditions of service, conform with the minimum standards expected by law at that workplace. But it's something we don't have, labor standards auditing. And because you don't have it, that's why we appear to have haphazard standards. Of course, we tried suggesting when we said we should have a labor standards bill. In other words, we should have a law, an institutionalized law that says this is the minimum labor standards that all employers must adhere to. You can give us something higher, but certainly not lower than that. But unfortunately, even that bill has not seen the light of day. But I believe sincerely that if the Ministry of Labor, for instance, discharges its labor standards auditing, some of these things that come to us in court today will not come, because they would simply advise employers that, look, this thing you are doing is below the threshold. Better work on it. This is the minimum you can go. And once you do that, I attended one of the functions of Lagos MBA some few years back in Lagos. And a woman who was one of the, from the corporate world, said something very touchy, and I think is something I should share here. She said, sometimes for us at NIC, we forget that individual organizations have their culture, how they do things. I said, yes, we may not know it, but have you asked the question whether your lawyers have tried to bring it to the fore in terms of pleadings? As a judge, there's a limit to which I walk around shopping for things. Everything depends on what is brought.
Yes, madam.
If an employee says XYZ, don't forget what is the rule regarding proof of custom and usage. It must be corroborated. So the man comes and says, it is the policy of this organization to do XYZ, and he does not corroborate it. Of course, as a judge, I'm not going to even look at it again. Now, if he says that, and the employer now says, look, over time, this is the culture. This is our way of doing things here. It is now a question of whether that way of doing things falls within the threshold of unfairness. If the answer is no, of course, we are going to get a verdict in your favor. But like I said, I am yet to see the kind of industry that lawyers bring in terms of the cases that come before us. I have challenged lawyers to pick some of our cases just randomly. Go and pick the case file and read through it and read the written addresses of counsel. Then go and read the judgment and tell me the percentage of input of the lawyers in that judgment. I've had cause to tell a lawyer, I said, after this, you now use this judgment and tell me you are applying for silk. When in truth, you didn't do much in terms of even the research content. Lawyers need to sit up. I've always said it. The third alteration has given us an opportunity to go back to school. We cannot interpret the third alteration in the light of common law principles. If you say you want to do that, you are getting it wrong, because the third alteration, if it wanted to restate common law principles, there would have been no need for third alteration. But because there are problems with the common law principle, that's why the third alteration came. And if we are not ready to look at it from that prism, then we are in trouble. The third alteration did not come to maintain status quo. It came to change it. And the earlier we realized this, the better for all of us. I've had cause to be invited by employers. In fact, I did a lecture for them, I think that year that the lockdown, 2020, we couldn't do it, but I think it was last year we finally did it or so. They asked a simple question: what should employers expect from you, National Industrial Court? That was their question. Because for them, they said, look, we are beginning to see things that we have not seen before. I said, yes. And by the time we finished, most of them sat back and said they were going to call their lawyers, let them sit down and begin to look at, in total, their HR policies as a whole. I had cause to even tell them, I said, yes, most of you here are HR practitioners. But don't forget, these same rules you do are the same rules that will be worked on you tomorrow when you come to court.
Absolutely.
We have seen cases where a HR man who came to testify against another employee, the following day was filing an action on the same issue in National Industrial Court, and now was the complaint, the claimant. My predecessor likes to say, today you are on this side, tomorrow you will be on the other side. So it behoves on you to make good HR policies in your workplace, so that whether you are there or you are not there, the point is, I mentioned on Friday,
yes,
we employed workers. We employed workers, but what we got were human beings. The fact that you were employed as a worker does not mean you are no longer a human being. Does not mean human rights don't apply to you. They do. And if those rights are brought to the workplace, they have to be looked at within that context. So some of these things, we need to appreciate it in this light. And that's the only way we can begin to understand what NIC is doing, what NIC stands for. Yes, I always tell people, there's the accusation that we are an employees court. I am not denying it, because the very structure of a labor court was because of the low bargaining power that workers had. But it's foolhardy for me to stand here in public and say our decisions are always pro-employee. No. Last week, I did a case where the defense did not even enter defense, and yet the claimant lost. Because if you don't meet the minimum threshold, nobody is going to give you judgment. It's as simple as that. Something I need to stress here. If you look at, I think earlier, Mr. Inam Winston said something about NIC claims for monetary claims are now treated as special damages, which must be specially proved. And usually, if you read our cases, there are two principal requirements you must prove. One, entitlement to it, which we say must be by way of an instrument. And that instrument can be either a collective agreement if you are a member of the union, circular if you are in government, statutory instrument, contract of employment, or conditions of work. You must show entitlement. And then you must show how you arrive at the quantum of what you are asking for. I'll give you a simple example. When you are claiming for gratuity, gratuity is usually a percentage of your salary over a number of years. Some conditions of service talk about gross salary, some talk about net salary. So if you are claiming gratuity, common sense tells you the first thing you must plead is your salary. I have seen cases where people were claiming gratuity and they did not even plead salary. Once you don't plead salary, is a non-starter. How do you expect a court to give you? No matter the English language you do, there's nothing the court can do if you don't plead their salary. If gratuity is based on net salary and you pleaded gross salary, it's a non-starter. Because they cannot use, a court cannot guess what your net salary is. You must prove it. And when you prove it, you must. Sometimes you see, I've seen lawyers say, we pleaded this in our pleadings and they were not controverted by the defendant. Special damages are not proved based on defendants not controverting. You are supposed to prove to the satisfaction of the court. So if you say your net salary was 10,000 naira, that is oral evidence. If you don't put your pay slip to show that it's 10,000 naira, and you said there was an admission by the defendant, you are wasting your time. No court of law will accept that. And there are cases that say, when it comes to special damages, be careful how you utilize oral evidence unless it is corroborated. But what we see every day, and that's why I keep quarreling even in court. I say, look, somebody like today complain about why is it that it's only NIC decisions that were cited. Yes, NIC decisions were cited because that's the starting point. It is when you know what NIC does, you can afford to say, look, what you did in this case is wrong because Court of Appeal said X, Y, Z, Supreme Court said X, Y, Z. I've seen cases where somebody came to me when the 2006 Act was passed on interpretation of Section 7 as to what the word labor is. And Court of Appeal and Supreme Court decisions were cited. And I asked, were these cases interpreting Section 7 of the NIC Act? The lawyer said no. I said, then that's your distinguishing quality. I'm not bound by that decision. Give me a case that was defining interpreting Section 7 of the NIC Act, then we can talk. But if you go and bring me a case that is talking about something, I told you employment can be understood in three senses. If you carry a case on employment for vicarious liability purposes and you are citing it for employment law purposes, I'll tell you that's a non-starter. You've not yet started. In law, context is everything. These are things we must just have in mind.
My Lord, time not really on our side. I'll be truth. I'm not sure I've done justice to the questions. I mean, the questions just keep coming in and the comments. And I think it behoves of me not just to share the questions, but to also thank my Lord, especially by referring to what appears to be an overwhelming position in relation to what the comments are illuminating. Thank you so much, Your Lordship, illuminating, incisive, enriching, educative, and all. The adjectives just keep coming, my Lord. No doubt it's been another rewarding session for every single participant on today's session. And that's because of the quality of the panelists, starting from Mr. Enan Wilson, Dr. Akombi, and of course, my Lord, I with special leave of court, to call my Lord the big masquerade in the room. So that is all that we remain grateful. And I would, at this point, now hand over back to Unta, or the Inter pleases Toby Nahin to do us the special honors of thanking my Lord. We won't be able to take questions anymore. Thank you so much.
No, but he asked that you thank my Lord on behalf of
yeah, my Lord. Okay, my Lord, again, in extending the appreciation of the whole bar, the Nigerian Bar Association, first, my apology that my video cannot come on. I've been struggling with the I've been in transit. It's just that this is just a session I couldn't afford to miss, and every time that comes on, the quality of the audio is affected. So that is why, my Lord, I deeply apologize that video is not on. At this point, I thank your Lordship for joining us, and this is the second session, and like one or two persons commented, it's very rare to find a judge, how much more the head of court, and join in a session of this nature. And I'm very accommodating to take all the questions and to share his thoughts, and very profound in all the responses given. Elucidating lecture. My Lord, we cannot thank you enough. We know you well enough that it is just not possible to have my Lord in a 4-hour session to interrogate on an engagement that my Lord does every day and is very familiar with and is very passionate with. And then, like I've always said, being the academic benchmark to refer to, and in the new labor jurisprudence that we're all talking about. My Lord, we thank you greatly. It's an honor. We really appreciate, my Lord, for joining us. And then we have no doubt that we'll soon reach out to my Lord again. And we know that my Lord would always accommodate us again. Thank you very much, my Lord. And to all the families and all the contributors, all the participants, we thank you. And then we look forward to having you again on the last leg, which is scheduled for Wednesday, when we'll be back for another session, still employment law, and then we have another rich array of speakers come and interrogate related questions. Thank you very much for joining us.
Thank you, everyone. Bye-bye, and see you on the 6th. All right.
Thank you.
Bye.
Thank you.
Bye-bye.